Good evening, everyone. Good evening, everyone. My name is Sarah Ellyn, and I am co-president of the League of Women Voters of Glen, Ellyn. My fellow co-president, Michelle Forthell, and I welcome you to our February community meeting. We are happy to have all of you joining us either here in person, and also happy that many of you may be joining us virtually on Zoom. Welcome to everyone. The purpose of the League of Women Voters is to promote political responsibility through informed and the active participation in government. The League works to increase understanding of major public policy issues and influences public policy through education and advocacy, like tonight's program. The League does not support or oppose any political party or any candidate. Here to tell us about this evening's program is our League's VP of Program, Bruno.
Thanks, Sarah. Well, good evening, everyone, and welcome to tonight's program, Privacy and Reproductive Rights in a Post-Roe Era. I'm going to provide a little bit of context for the program and then go over what we're going to put forth tonight. So a bit of background related to privacy and reproductive rights. As I think most of you know, for over 40 years, the U.S. League of Women Voters has held public policy positions on individual liberties and on reproductive rights. And for over 40 years, the League has stood firmly on these positions as they've acted tirelessly in the courts and the legislative arena to protect and promote civil liberties and reproductive rights. So in September 2021, the U.S. joined a coalition of civil rights organizations and filing an amicus brief in the Dobbs case. Well, in June of last year, when the Supreme Court decision overturning the constitutional right to abortion, which was recognized for over 50 years, was handed down, the U.S. League President, Dr. Deborah Turner, and U.S. League CEO, Virginia Case Solomon, issued a joint statement, which in part stated, today's ruling strips women and those who may become pregnant of their bodily autonomy. When women and those who can become pregnant can no longer make reproductive decisions for their own bodies, they are no longer equal individuals in our democracy. This harm will exacerbate societal inequalities and fall disproportionately on people of color and low-income communities already facing egregious obstacles to healthcare. So, our 40-year-old position on public policy and reproductive rights was announced by the National Board back in 1983, and it states, the League believes that public policy in a pluralistic society must affirm the constitutional right of privacy of the individual to make reproductive choices. So the big question, is there a constitutional right to privacy? Well, it is indeed complicated. And that's our program tonight, right? So tonight we're going to hear from our featured speaker, Professor Steve Schwinn, who can help us gain a better understanding of the complexities surrounding the presumed constitutional right to privacy and what might be in stake for other freedoms in a post-Roe era. Following Professor Schwinn's presentation, we'll take a few minutes to consider the socioeconomic impacts of women and children in a post-Roe era. So we'll hear from our League's very own Dr. Bob Bruno, who is a professor of labor and employment relations at the University of Illinois School of Labor and Employment, Urbana-Champaign. Dr. Bruno directs the Project for Middle Class Renewal, the university's Labor Policy Center. He is recognized as an expert by national and local media on employment and labor policies. So later this evening, Dr. Bruno will briefly share a summary of a recent study on the economic outcomes for women and children in Illinois versus those in states with abortion bans. So we will have time for questions, either a little bit during the presentation or afterwards. If you have a question for the presenter, just raise your hand if you're here in person. If you're attending on Zoom, you can click the Q&A button at the bottom of your screen and type in your questions, and our VP of Communications, Karen Daly, will present your questions to the presenters. Even though we try, we may not get to all of your questions. And just a few more points. As with every league meeting, we ask that questions be relevant to the evening's topic, and then we ask that everyone proceed in the spirit of learning and mutual respect. And I would like to also point out the meeting's being recorded, and we plan to post the recording on our website in the future. Now, to introduce our key speaker is our Glen Ellyn member, visual artist and researcher extraordinaire, and my partner in planning tonight's meeting, Lynn Bruno. And I have to say, Lynn created this graphic that's on our directory. And she also is responsible for all the great documentation on the history of privacy that's inside here. All right, thank you, Lynn.
Thank you. So it's my honor and my privilege to introduce Professor Schwinn this evening, our featured speaker. He is a professor of law in the law school at the University of Illinois, Chicago. His area of expertise is constitutional law, and he's often asked to respond to issues around the Constitution and human rights. In his capacity as a professor, he teaches constitutional law, First Amendment, comparative constitutional law and human rights, and civil rights. Widely published, his scholarship has appeared in a variety of blogs, journals, and reviews. He's co-founder and co-editor of the Constitutional Law Prof Blog and an occasional contributor to other blogs and publications. He is editor of the American Constitution Society Supreme Court Review, an annual publication reviewing cases and issues at the Supreme Court. And he regularly writes for the American Bar Association Preview of United States Supreme Court cases. In addition, he's co-director of the International Human Rights Clinic. He served as the Edward T. and Noble W. Lee Chair in Constitutional Law in the year 2015-16, and again for the spring term of 2023. Finally, Professor Schwinn litigates cases pro bono in the federal courts. He works with area schools, teachers, students, and nonprofits on outreach and public education related to the Constitution, and he serves on the board of several local and national organizations. So please join me in welcoming.
Thank you, Bernie. Thank you, Dr. Bruno. Thank you, everybody. This is such an honor and thrill and pleasure to be with you tonight. I really appreciate it. Bernie, you may have oversold me. I'm not sure I'm going to answer any questions tonight. I just want to warn everybody, you're likely to leave here with more questions than answers, and maybe more than you came with, unfortunately. We're talking about privacy and reproductive rights in the post-Roe era. This is a huge topic, right? Like super huge in ways that I am going to try to talk about in the next 30 minutes. And given the background that Dr. Bruno has put together for you, I'm assuming that you all are steeped in this stuff, that you've got a fairly deep understanding of some of these concepts. So I'm going to talk to you the way I would talk to lawyers, for example, if that's okay. And if you have any questions, just let me know. If you have any comments, that's fine. If you have any complaints, you can just please keep it to yourself. And what I thought I'd do is just kind of start big picture and try to frame these issues, what I tell my students, at kind of a 30,000 foot level, to sort of give you a political context, a constitutional political context for what's going on. And then we'll narrow down into the Dobbs case and talk about specifically what's happening post-Dobbs with reproductive rights and the right to abortion, and then other rights. And then we'll kind of funnel out again and talk about how Dobbs is implicating other rights and other things in the Constitution and our constitutional political debates more generally. Okay, so we got a lot to cover. You ready? All right, let's do it. Okay, so I want to start with this idea that we've been having a long-running debate in this country about how to interpret indeterminate and vague constitutional provisions, right? For example, what is equal protection in the 14th Amendment? Or what does due process mean in the 5th Amendment or the 14th Amendment? And so there are a lot of different schools of thought, but we can basically divide them into two. One is originalism. You're familiar with that term, originalism? Okay. The other would be living constitutionalism. Does that ring a bell? All right, I'm just going to define those really quickly, and we'll come back and talk about them sort of later in the talk. So originalism is the idea that we understand vague and indeterminate concepts in the Constitution by the original understanding or original meaning that was given to them at the time. How did people use those terms at the time? And therefore, how did they expect us to use them when we interpret the Constitution many, many years later and inconceivably forever into the future, right? Living constitutionalism, I'm not a huge fan of that phrase, but let's call it that for now. Living constitutionalism is the idea that a concept like equal protection or due process, it ought to kind of morph and adjust over time in reaction to changing economic circumstances, social circumstances, changing technology, changing politics, right? All the things that change in our society, that it shouldn't be a static hidebound constitution as an originalist would have it, but rather a living, breathing document that morphs and adapts to our time. So given that construct, if we kind of narrow in just a little bit, we can talk in our Constitution about two kinds of rights. One kind of right would be enumerated in the Constitution. Think free speech, right? The First Amendment protects free speech. We know that. Another kind of right would be what we call an unenumerated right in the Constitution. And here we're thinking about something like reproductive rights, or in particular, a right to abortion, right? It's not in the Constitution, but the Supreme Court has interpreted the Constitution to include it. We call it an unenumerated right. Now, for our purposes, we can consider those rights on par with each other. There's no particular difference between them. One's listed, one's not, but that's okay. We can sort of deal with that. When the Supreme Court deals with a government intrusion of a right, it generally assesses the legality or the constitutionality of the government action using a particular standard of review. And in particular, what it says is if a right is fundamental, whether it's enumerated or unenumerated, the court applies a standard called strict scrutiny. I'm giving you a lot of technical stuff right now. Trust me, it'll become important. Strict scrutiny means that the government action has to be precisely tailored to achieve a super important, compelling government interest, which means that anytime a government intrudes on a fundamental right, the courts are likely to strike that rule or regulation, right? On the other hand, something that's not fundamental, the court counts, for example, economic interests, right? Economic interests will be subject to a very different test. It's called a rational basis review, a very low-level review, where most government action that intrudes on economic interests will be upheld by the courts. So we've got these two sort of polar opposite reviews. One corresponds to fundamental rights, where government action is usually struck. The other corresponds to basically everything else, where government action is usually upheld. So what about unenumerated fundamental rights, right? Like, where do they come from? How do we establish them? Well, through a line of cases, the Supreme Court has come up with a kind of construct for unenumerated fundamental rights that I want to share with you, because this then will help us understand what's going on with the court's jurisprudence post-Roe. Okay, it's a two-step process. In step one, now remember, these are unenumerated rights, and so they're not yet determined by the court. If you're arguing to the courts, I want a new right that the court hasn't yet established, how do you argue, right? Maybe a right to healthcare, for example, right? Which is not a fundamental right now, but maybe you want to establish it as a fundamental right. We ask two questions. The first question is, what is the right? Like, what are you arguing for? And here you can think about rights at different levels of abstraction. Take something like the right to abortion, right? At its most abstract level, we can think about a right to abortion as a privacy right. It's often described as a part of the family of privacy rights. At its most particular level, we could think of the right to a particular woman to an abortion under particular circumstances at a particular time and place, right? Sort of the most specific iteration of that. We can argue at different levels. That then leads into the second question that we ask, and that is the right deeply rooted in our nation's history and tradition? Is it deeply rooted in our nation's history and tradition? Okay, and the court will assess that by looking at laws and practices, going back to English common law, through early American law, through 19th century law, through 20th century law, and what's the trend line, right, with regard to state control or state regulation of a claimed right, deeply rooted in our nation's history and tradition. Now, I'm going to ask you a question that I ask my students at this point. If a right is articulated at a more abstract level, do you think it's more or less likely to be in the history and tradition? Think about the right to abortion as I've described it. Is the right to privacy more or less likely to be deeply rooted than, say, the right to a particular woman to a particular abortion in a particular state at a particular time and place? It's more likely, right? The more abstract you describe a right, the more likely it is to be in our history and tradition. The more specifically you describe it, the less likely it's to be in our history and tradition. Now, in terms of constitutional politics, maybe it won't surprise you to learn that progressive justices on the court like to define new claimed rights at a higher level of abstraction, right? Because they understand that when you ask the question, is it deeply rooted in our nation's history and tradition? The answer is more likely yes. And you get a fundamental right that's unenumerated, like a right to abortion. If you describe it at a more specific level, you won't be surprised to hear that our friends on the conservative side of the aisle favor that specific level. Justice Scalia, in particular, if you remember him, was famous for writing, when the court identifies a right, it ought to articulate it at the most specific level possible, right? The right of a particular woman to a particular abortion in a particular state at a particular time and place. That specificity, and then ask if that's deeply rooted in our nation's history and tradition. Of course it's not, right? Of course it's not. Here's another example. Think about the Obergefell case. Do you remember this from 2015? Same-sex marriage. So the case comes to the court, and the argument is, well, what's the right? What are you arguing? Well, people who favored a right to same-sex marriage argued that the right was a right to marry at a higher level of abstraction, or maybe a right of one person to marry another person, right? Still a relatively high level of abstraction. Whereas opponents of the right were arguing, no. The claimed right is the right of one man who will marry one woman, or one woman to marry one woman. And you see how that matters, right? Because the right to marry another person, well, of course, that's deeply rooted in our nation's history and tradition. Who can deny that? But the right of the one person to marry a person of the same designated sex? No way. I mean, that's the whole point of the case, to get to that right, right? And so you can see the constitutional politics even playing out at this basic level. Now, the right to abortion is and always has been a little bit different since Roe versus Wade. I told you that the court will apply this higher level of strict scrutiny to fundamental rights, a lower level to everything else. Abortion has always been kind of a different animal for the court. And the reason why is because the court has said that a woman's right to abortion is not a standalone kind of thing. There's also a state's interest in the pregnancy that grows over the course of the pregnancy. That interest is in the potential life of the fetus. And so in Roe versus Wade, the court constructed a trimester framework that accounted for a woman's privacy interest and her own sort of right to determine her own health care, right? Important, critical, fundamental, but also counterbalanced by the state's increasing right over the course of the pregnancy in the potential life of the fetus. In 1992, the court came back and modified that trimester framework in Casey, Planned Parenthood versus Casey, and pegged the point at the point of viability, the point where a fetus is viable outside the womb. And what the court said was, a woman has a fundamental right to abortion up to the point of viability. And a state can regulate abortion so long as the regulation isn't an undue burden on a woman's right to get an abortion. Post viability, a state can go so far as banning abortion entirely, so long as it provides an exception for the life or health of the woman. Okay. And that was the picture going into Dobbs. So you can see that abortion is a little bit different right out of the gate. The court has always treated abortion a little bit different than other fundamental rights. But the reason that I mention other fundamental rights is because the Dobbs ruling could potentially impact them. Hold on, let's talk about Dobbs first. Okay, I'm just going to pause here for a second. And are there any questions or comments so far before we drill into Dobbs? Are we okay? Okay. Is this, I gotta ask, is this giving you what you want? Is this what you get? If it's not, tell me. I need to adjust.
We're waiting to find out whether we have a right to privacy.
Okay, okay. Okay, don't wait any longer. No, yeah.
All right, now we're going to go.
Okay, yeah,
So you mentioned the state's interest,
yeah.
you know, from the first trimester. So what is the example of that? What's the state's interest?
Yeah, so the way the court described it in Roe versus Wade was the state, think of it as kind of an increasing interest over the course of a pregnancy. The interest in the first trimester is at a minimum, if it even exists, because the fetal development at that point, the fetus is, I don't want to sound too crass about it, but basically an appendage in the woman. It can't exist on its own, right? In the second trimester, the state has an interest not in the potential life of the fetus quite yet, but rather in the woman's health and safety, because the court said in Roe versus Wade in 1973, this is Justice Blackmun sort of holed up at the Mayo Clinic and its lawyer trying to be doctor, saying it's in the second trimester where abortion could be unsafe for a woman. Right, not in the first trimester, but in the second trimester. And so therefore states can regulate abortion so long as it's targeted at protecting or preserving the life or health of the woman. And in the third trimester, the court said that's post viability, and that's where the state's interest in the potential life of the fetus, potential because it's not yet born, but nevertheless viable outside the womb, according to the court. And therefore, the state's interest in the potential life of the fetus is at its apex. And the court's interest in the life or health of the woman also increases because abortion becomes more dangerous in the third trimester, right? And so therefore, the state can go so far as banning the procedure entirely in that third trimester in the interest of the potential life of the fetus, but with an exception for the life or health of the woman. Now, what's interesting about Casey is the Casey court said, look, with increasing time and technology, this Roe trimester framework is going to collapse on itself. That's because abortion is going to become safer and safer longer into the pregnancy, right, on the one hand. And on the other hand, a fetus will become viable earlier and earlier in the pregnancy so that the trimester framework collapses. And the court said, instead, we're going to use this point of viability as the turning point in the pregnancy, where before a woman can get an abortion, so long as the state can regulate it, so long as it's not an undue burden, then after the state can go so far as banning it entirely, if it wants to, it doesn't have to, with an exception for the life or health. And so it's the reason that it's different. I mean, I don't want to sound too cute about this, but because Justice Jackson wanted to play, or Justice, well, really the court wanted to play doctor and figure out what are the competing interests in a pregnancy. And that's kind of how we ended up with Roe, and then how Casey adjusted it. And then after Casey, well, really after Roe, but especially after Casey, we just saw this concerted effort by the states to tee up a case to overturn Roe versus Wade and just completely overturn that framework. And so states were doing all kinds of things with their abortion laws, trying to attract the Supreme Court to take a case to overturn the Roe-Casey framework. We saw a number of states doing this, as you know, right? Finally, the court took the bait with the Dobbs case. This was a 15-week ban on abortion. There's a lot to say factually about the Dobbs case, but I think in the interest of time, I'm actually not going to talk too much about it unless you have questions about the case itself. But what the court ended up, what I mean is the factual background of the case is really kind of interesting. There were good reasons why the court never should have taken the case in the first place. It was a kind of lousy case for the court to take to test this. We're going to skip that just in the interest of time. What the court did was overturn Roe versus Wade, as we know, and overturn Casey and say that there is no fundamental right to abortion. And what the court did here was I think really interesting and something to keep our eye on. Remember the historical approach that we talked about in determining whether a right is fundamental in the first place. That's what the court reverted to. And what it said is when we re-examine whether there is a fundamental right to abortion against our history and tradition, that second question, remember, right? Is there a deeply rooted right to abortion in our nation's history and tradition? The court said no. It traced history and tradition from early English common law to later English common law to early American colonial law to or late 18th century law, 19th century law, all the way through the 20th century. And it said at every step, states were regulating abortion in a way that the court interpreted to mean that they didn't respect a woman's right to abortion. Now, there's a lot to say about the court's historical approach. First thing we might notice is that judges are not historians, right? And they actually do history really, really badly. I'll say more about that in a few minutes. So their historical interpretation is just kind of whack, right? I mean, it's just off. But one thing caught my attention. One thing that the court did repeatedly in its historical sort of recitation of all this law was to say, look, under English common law, early colonial law, early American law, early state law, one thing was consistent, and that is that states were banning abortion post-quickening, right? Banning abortion post-quickening, quickening being the time when you can feel a baby kick or fetus kick or move its arm or whatever. And they interpreted that to mean that states and common law were regulating abortion such that it wasn't a fundamental right, which sounds okay post-quickening. But my question was, why doesn't that mean that there was a fundamental right pre-quickening, right? And why doesn't that line up exactly with the Roe Casey framework? It seems to me, given current medical understanding, it seems to me that's exactly what Roe and Casey were saying. The court didn't say that. What it said was this idea that the government was regulating abortion, banning abortion post-quickening meant that there was no fundamental right to an abortion. And so the idea of abortion goes away, fundamental right to abortion goes away. And now abortion is just like everything else that's not a fundamental right. Remember, I mentioned economic interests, where when the court reviews a state restriction on it, it will apply rational basis review and almost always uphold the state restriction, which just invites states to ban abortion. And that's exactly what we've seen. I'm going to pause again to see if there are any questions or comments before we kind of see the implications of this. Yeah,
Can you speak up just a tiny little bit if possible?
I'm sorry.
Can you speak a little louder?
Oh, yeah. I'm sorry. Yes, of course I can. Yes, absolutely.
Thank
Yeah,
you.
yeah.
But my understanding is that abortion was quite legal and quite common in the early stages of our country. And it wasn't until doctors wanted to control that it became an issue, correct?
That's my understanding as well. I will confess, I'm not a historian either. I'm just a lawyer. And I'm as bad at history as those on the court are, but that's my understanding. Yeah. We'll talk in a second a little bit more about this idea of looking to history and shortcomings of judges doing it and what the court itself had to say about that, which I think is really interesting.
So there's a question online. Why didn't SCOTUS align their position on post-quickening with there being a fundamental right?
And I don't know. I can editorialize a little bit and say that I think that the justices are voting with their politics, not with their constitutional law, certainly not with their history. But that's just me. Yeah, I mean, we'll have to use our own judgment. Well, we'll talk in a second about significant shortcomings in the court's historical approach. I've already mentioned a couple obvious ones, and you mentioned another, right? That it just doesn't really align with reality. We'll see another example of that in a second. But let me talk first about what happened immediately in response to Dobbs in the right to abortion world. Immediately, the states kind of went in one of two directions, either ban abortion or to allow abortion, right? And many states were moving in that direction already anyway. A lot of states had these so-called trigger laws that as soon as the court overturned Roe versus Wade, the law went into effect, categorically banning abortion. And so those laws went into effect. We saw a lot of litigation, and we're still seeing the kind of fallout from all of this. But the basic picture is that we've divided as a nation more or less half and half, with states that are pro-choice and pro-life, right? That states have either allowed abortions or they've regulated abortions to various degrees. But that's basically the picture. We have seen some state courts rule under state constitutional law that there's a fundamental right to an abortion, and some of these have come from surprising places. So the Florida Supreme Court, the Kansas Supreme Court, South Carolina Supreme Court, Montana Supreme Court, imagine. These are places that have ruled under state constitutional law that there's a right to abortion. And then in the midterm elections, we saw a number of states constitutionalize a right to abortion. Here I'm thinking Michigan, California, Vermont. We saw in Kentucky, we saw voters reject an attempt to constitutionalize lack of abortion, right? And so we're seeing a kind of, at the state level, we're seeing a kind of uprise of democracy, which I actually find really inspiring. We've also seen some state legislatures move to enact state law that protects the right to abortion, and in some cases protects it even more than they did pre-Dobbs, recognizing that they could be an oasis for abortion for women coming from other states that ban the procedure, for example. We're still seeing the fallout of this, and I think we're still going to see it for a while. It's not clear to me that we're at an equilibrium yet. At some point, I imagine we'll come to something like an equilibrium. But there's still a lot of litigation, a lot of stuff going on in the states that actually is really, really interesting in terms of state. I think the way the court would describe it is state experimentation with policy, right? You know, sort of 50 different laboratories of democracy. And that's kind of what we're seeing right now. Then kind of moving out a little bit, the next, looks like the next front in abortion debates is going to be with medication abortion. You may know about the case in the Northern District of Texas, where opponents of the FDA, the Food and Drug Administration, approved a drug for medication abortion in 2000, 23 years ago. And they're just now getting around to figuring out that maybe they should challenge that approval as violating the Federal Food, Drug, and Cosmetics Act and the FDA's own regulations. And moreover, that they should challenge that in the Northern District of Texas that happens to have a judge that was appointed between 2016 and 2020 of the federal bench, we'll be nonpartisan about this, and that this is a judge who is notoriously conservative in his rulings and also sits within the Fifth Circuit, which is also notoriously conservative. So if anything's going to go to the Supreme Court, which is also conservative, it's this, right? We can talk a little bit more about that case, but I think that's the next front. There's a filing actually due tomorrow. And it's conceivable that we could have a ruling from this judge conceivably as early as tomorrow, but more likely in the coming weeks. And so that's one to keep our eye on, right? More generally, the reasoning of the Dobbs decision with regard to the right to abortion invites states to move toward fetal personhood. And I think that's where we're going to start to see states moving with state legislation to protect fetal personhood in various ways. A number of states have already done things like create a statute that criminalizes the murder of an unborn fetus, right? And I think we're going to see more and more of that. What the end point of that is, who knows? And the implications of that, I think, are, I mean, who can predict, right? So on the abortion front, that's what we're seeing. There are other implications of the Dobbs ruling itself in this historical approach. If what we're doing is identifying claimed rights at the most specific level of abstraction and asking if they're deeply rooted in our nation's history and tradition with this kind of twisted history that the court has adopted, well, you can see what's next on the chopping block, right? All the rights and the materials that you read for today, right to contraception, is that deeply rooted in something like English common law? My money is not by this court's reckoning. What about the right to sexual privacy and sexual intimacy here in Lawrence versus Texas, right? Is that deeply rooted way back to English common law? Again, my bet is by this court's reckoning, no way. What about the right to same-sex marriage? And you can bet that it'll be the right to same-sex marriage now, not the right to marriage, right? Is that deeply rooted? Again, my money's on no with this court and more. And so I think we're going to start to see the court chip away at, and in fact, in some ways, just kind of blast away at well-established fundamental rights. Justice Thomas, in his opinion, in the Dobbs case, alludes to this. And interestingly says, yeah, you know, these other rights, they indeed are on the chopping block, but you know what, for Justice Thomas, there's one that's not. That is the right to marry somebody who's not of the same race, right? In Loving versus Virginia. And so I think there is an end point to this, but I don't know where it is. And so I think that's going to happen. Outside of fundamental rights that are unenumerated, I'd mentioned that we're seeing the court apply this historical approach in other areas. We saw it in a Second Amendment case that came down this summer called Bruno, and we saw it in an establishment clause, a religion clause case that came down, the praying football coach case, if you remember that, paying attention to it, the Kennedy case. What the court said in both of those cases is we're going to look to history and tradition to measure whether a right is fundamental. And again, their history and tradition is just bananas. So in Bruin, for example, they looked to a history and tradition of regulation of firearms to determine whether the New York State Legislature could require good cause for a concealed carry permit. And they said no, that's not in our history and tradition, that the common law, early state law, later state law never regulated concealed carry and required good cause for that. Well, you know what one lower court has interpreted that to mean? That there's also a fundamental right for individuals who are subject to a domestic violence restraining order to get a weapon, to get a permit to carry a weapon. Why? Because looking to our nation's history and tradition back to English common law, well, English common law and states weren't regulating domestic violence, people subject to domestic violence restraining orders and their possession of firearms. Of course they weren't, right? I mean, the whole idea of domestic violence restraining orders is a recent innovation. And so you see what the problem is. Now, there was another problem in the Second Amendment case. There were scholars who have actually done work as more and more material is digitized. Linguistic scholars actually have access to a ton of information that we didn't have just as recently as 10 or 15 years ago. And so they can actually do a deep dive into the meaning of things like the Second Amendment from an originalist perspective. And what they're discovering is that this originalism isn't so politically conservative. It's actually pretty progressive. And so they're actually using originalism to give a progressive interpretation to the Constitution, which is turning our constitutional politics upside down. But these are linguistics and historians who know how to use these tools, right? So I said the court had something to say about this. Here's what Justice Thomas wrote about that in the Bruin case, when the complaint was, hey, you all are judges, not historians. Why don't you drive in your lane, right? What Justice Thomas said was, we actually are driving in our lane, because as judges, we're really good at taking evidence from different sides and then deciding which evidence is correct. And that's all we're doing. We're taking historical evidence from one side, historical evidence from the other, and deciding who's got the better case, right? These are justices on the Supreme Court making this decision. There's a lot of stuff above my pay grade, but that's way above theirs. I mean, that's just bananas. So, and to write this right in the Bruin opinion, I thought took a lot of chutzpah on Thomas's part, but there you got it. It's right there in black and white. And then just one more thing. So we tend to forget about something that happened before Dobbs. And that is that Texas, before Dobbs, wrote a law that allowed any individual to sue any individual who aided and abetted any abortion in Texas. This was SB 8, okay? And the statutory damages was a minimum of $10,000, plus the plaintiffs could get attorney's fees and court costs, right? Now, you don't have to think very far, you don't have to know anything about the law to realize with those kinds of economic incentives, abortion doctors are not going to perform any abortions in the state. Right? They're not going to, because they don't want to be sued. Even a frivolous lawsuit, they've got to pay court costs and attorney's fees. Crazy. Theoretically, that means that you and me here in Illinois could sue abortion doctors in Texas. It's just crazy. And the Supreme Court upheld it before Dobbs. A number of states had considered copycat laws in the abortion context, but they don't need to anymore because the state can just outlaw abortion under Dobbs. But here's the thing, it also set the precedent that any state can do that with any right, right? We talked about Second Amendment rights. There's nothing to prohibit the state of Illinois from creating an individual cause of action for me against one of my neighbors who's carrying a firearm. What? Or for a state to create a cause of action for anybody who's exercising a fundamental right and create the economic incentives within the statute so that that right can, as a practical matter, no longer be exercised. And the Supreme Court has nothing to say about that. I mean, I find that terrifying. So I'm just going to leave you with this. That's a really sad situation in my view, but we are seeing this kind of uprising of democracy at the state level, which I find very exciting. What I tell my students is, look, you know, Roe versus Wade came down 50 years ago. This effort to get it overturned was 50 years in the making, right? Very carefully calculated at every single turn. And you know what? They can make that kind of constitutional change. And if they can do it, we can too. That's what I tell my students. And that's the hope that I get from all this story. So I hope you get that as well. Thank you. Yes.
Well, so speaking of history tradition, so 50 years since Roe versus Wade, only 100 years since women have had the right to vote. So if you're thinking about history and tradition of the United States, most of the people in this room would not have any choice about anything 100 years ago, right?
Yeah, I mean,
we're
thankfully,
non-citizens.
amendment, but yes, yeah, that's exactly right. Yeah.
So what about that sort of the history of women not having those same rights is connected to what we're talking about here.
Absolutely. I mean, and that's, I think that's exactly right. I mean, if you're talking about a whole host of rights that, that women as a class might assert, right? By the court's reasoning, many or all of those are not in our history and tradition. They're just not. Now, we have the 19th Amendment, which allows women to vote. I mean, even as I say that, you think how crazy that is. You gotta kind of laugh. Of course, women can vote, but other things, not in our history and tradition. Yeah.
Well, one of the questions that was connected to that, are there any cases that have come before SCOTUS that challenges a man's right to regulate the privacy of their body? In your knowledge.
Yes, that's Lawrence versus Texas, and this is sexual privacy. Now, Lawrence versus Texas is kind of interesting too. This case came down in 2003. It was individuals who were challenging the constitutionality of a Georgia anti-sodomy law that was enforced against a gay couple. The court in Lawrence versus Texas upheld the right of sexual privacy and overturned the Georgia sodomy law. But in doing that, they overturned an earlier case called Bowers versus Hardwick, where the court, get this, did an historical approach to determine that there was no fundamental right to what the court called homosexual sodomy. I'm using air quotes because that's exactly the court's language. I wouldn't use that myself. That there was no fundamental right to that because it's not deeply rooted in our history and tradition. Well, of course there's not. In 2002, the court came back, or 2003, the court came back in Lawrence versus Texas and said, wrong question. What we ought to ask is there a right of two consenting adults to sexual intimacy, right? Well, of course there is. Of course, you see how the question matters. Well, how the court analyzed history mattered too. Like all of this is political. Yeah, so the answer is yes, and then that just opens up a whole discussion about history.
So can you kind of talk about privacy rights? Yeah, with the government kind of surveilling people, being able to tap into, I mean, with the abortion bans, they're going into people's, apps on their phones and all of that kind of stuff.
I can. So we were talking about this a little bit before. The right to privacy think of it as the Fourth Amendment context, right? Warrant, search and seizure type privacy operates a little bit differently than the kind of privacy that we've been talking about. And thank goodness the court has actually been reasonably protective in recent years and decades of the right to privacy in the Fourth Amendment context. And I expect that that'll continue, probably even if the cases touch on the right to abortion in one way or another. In some of the materials that you distributed for tonight, I saw something that I actually had not seen before, and that was a prosecution of mother-daughter who got the abortion contrary to state law. Right. And then the authorities got a hold of their text messages that were planning the abortion procedure. I mean, that's really distressing, right?
Yeah.
But also probably legal if authorities have reasonable cause to think that searching something like text messages will help uncover an illegality that is getting an abortion. That's probably okay if they get a warrant and can show the requirement for the warrant. But in terms of just sort of randomly searching people's phones, and we hear a lot about, for example, does the government have access to, if you're using an app on your phone that tracks your ovulation cycle, for example, can the government get access to that? Not willy-nilly. They would need specific evidence or specific probable cause of an illegality before they could do that. And then they'd have to go to the judge again. And so that the illegality all hinges on whether the state has made abortion illegal, right? And that, so it all kind of traces back to that. Yeah, I know.
Kind of scary.
Kind of scary. Kind of scary. Yeah.
Yeah. Question online, another question online here. Did the framers of the Constitution offer any insight into how the Constitution might be viewed centuries later?
Great question. Yes, and the best historical evidence on this actually says that when they wrote indeterminate, capacious, and vague clauses like equal protection, they actually intended for us to interpret those according to the times, a more living constitutional approach. And part of the reason that we know that is because when they wanted to write determinate provisions, they know how to do it, right? Members of the House served 2 years. It's right there in the Constitution. They wanted to write something determinate. They know how to do it. And yet they didn't with something like equal protection. They left it open for the ages. Good question. I'm gonna be really selfish here and sit my butt down because I can't wait to hear from Dr. Bruno. So, I want to thank you all, everybody. This was a true pleasure and honor. I do appreciate it. But
Thank you for that informative presentation. I still don't know if there's a constitutional right to privacy. I guess it all depends.
Complicated.
It's complicated. All right, well, we want to take some time now to consider some of the socioeconomic consequences of a post-Roe era. And Dr. Bruno, we welcome you as the professor and director of the Project for Middle Class Renewal at the University of Urbana-Champaign to share the findings of your study on the economic outcomes for women and children related to abortion bans. Dr. Bruno.
Thank you. Wow, that's going to be a whole lot to follow, frankly, and all that fear and loathing and bad news. I'm trying to figure out how to redo this so that it ends on a high note. But I think Illinois actually is a wonderful and positive example of a state that has created laws and policies and an infrastructure that is friendly to women and children. And I know you hear a lot of bad news about Illinois. But this is not, this is an exception to maybe some of the things that you've heard. But you can see the title, and after listening to Stephen's presentation, I think there could be a subtitle that we work into this. What happens when women do not have a fundamental right to control their own body, right? What happens in the material reality of the life that they experience, and control over the body, having sovereignty, agency, is so critical to any sense of liberty, right? And you don't have to be a constitutional lawyer, I think, to appreciate that. But what we attempted to do in this, what we call a baseline study, is to point out how critical it is that women have fundamental control over their own body, because it's the body that works, right? It's the body that labors. It could be emotional labor that they're compensated for. It could be intellectual labor, physical labor, but it's all encompassed in the body. And if you don't have control over your own body, if you don't have reproductive health rights, and you're not able and you're not free to get into the labor market, you are dependent, right? And that has enormous socioeconomic impacts. So what colleagues of mine and I set out to do is just to create, it was a pretty simple baseline study, but it hadn't been done before, where we looked at women from the ages of 18 to 45. And in Illinois, that's about 1.8 million women who are in the labor force. So a period of life where there's active membership, involvement in the labor force, and corresponding to a period of life when control over reproductive health would be very critical. And we said, well, let's take a look at how women are doing in that bracket who are working, how they are doing, how are they making out economically, right? How are their children doing? And then let's look at the states, and you heard Stephen talk about the various bans that went into effect. Let's look at states, 20 of them, who have already either banned abortion or made it very clear that they were going to ban abortion. And let's just do a baseline study, because we don't know yet what the effects will be of all these bans down the road. We'll have to look, but let's take a look at a state like Illinois that has what we would consider to be policies and laws and an infrastructure friendly to women that protect reproductive rights. And let's compare it to these 20 states, okay? And we'll compare it women 18 to 45, and we'll look at their labor force participation. And let's draw some comparisons, because the thinking is now after Dobbs, if Illinois were to look like these other 20 states, right? What would the loss be? What would be different? Okay, so we do this real simple comparison. And what you see on this first slide, and by the way, I really appreciated how brilliantly Stephen conversed with all of you. No slides. He's probably a better talker than me. Number one, he's a lawyer. And number two, I got a few numbers, and I figure when you got a few numbers, it's better to show you some pictures, and the team is pretty good at infographics. So just briefly, right? I'm just summarizing. I only have a couple of minutes. If you want to look at more data and look at tables and charts, you can read the report. But you can see for yourself that on a number of dimensions, women in Illinois in this age bracket really do much better than women in those 20 states that have banned abortion or are committed to doing so. So this is just one snapshot, but these are clear differences. Now, again, imagine if Illinois were like the other 20 states, there would be that loss, right? There'd be that loss of income. There'd be that loss of health insurance. Fewer would have bachelor degrees, right? There'd be a greater percentage that would be in poverty. They'd be less likely to be employed. Now, we could do further analysis and show you what the loss of the state's economy would be if you pulled out a big chunk of that 1.8 million. And of course, it wouldn't be all 1.8 million. But women are about, they're slightly more than 50% of the population in Illinois. What would it do to the state's overall economy? And certainly what would it do with middle class, working class, and lower income families? And there's an important statistic that we'll end on in that regard. So again, I'm being very brief. A couple of highlights. How do children make out in comparison? Well, less likely, in Illinois, they're more likely to have health insurance. And of course, those children are less likely to live in poverty. And then in the bubble, just a summary finding, what the research shows is that that legal access to abortion, that fundamental right to control the body, to determine your own agency, lowers childhood poverty, improves children's educational outcomes, and reduces teen pregnancy. And in the report, there's statistics and data that will show you where that is. Okay? So looking at our baseline study and then looking at previous research that had been done, it's pretty clear. In fact, it's obvious that reproductive health care rights really are economic rights. And if we think about how important having some economic power is in society, the lack of it really subjects that population to almost a second-tier citizenship. And again, I'm not going to read the slide. My wife wants me to read them. Well, then I guess you make a good point.
can see
You know, you're always told,
Yeah,
oh, they can't.
they can't see the slide. Yeah, we got it covered.
Would you come home with me? You use an advocate.
Yeah.
Good representation. All right, well, I think you can see, right? You can see the difference from these numbers and the impact, right? We're heaping debt, quite frankly, on women who are denied abortions, and their children, of course, bear that price. And it's multi-generation. How do you break that cycle? It becomes very, very, very difficult. These are the last two pieces of data. I mean, that last data point, right? Bankruptcies and evictions are much higher. So you're going to be homeless. You're going to have no assets. You have no capital that's built up. You have no credit. How do you find your way through the labor market? How do you build just a life? How do you move up the economic ladder? And then finally, 49% of women, I will read this one, who seek abortions have family incomes below the federal poverty line. If they're not able to control their reproductive health, they're not going to be able to enter the labor market. And we've got strong, still, I think, Steve, we still have strong constitutional rights in some areas, but nowhere in that Constitution, my knowledge, is there a right to work, a right to health care, a right to education. I do my own little fun questions with my students, and I ask them to sort of talk about all these rights. Do you have a right to clothing? Well, no. Do you have a right to housing? Well, no. And there are statutes that provide no. Do you have a right to health care? Well, no. You know, no right to education, no work. Well, you know, you're hungry, you're naked, you're homeless, you're unemployed, and you're stupid. Because you have no rights, not constitutionally. That's not where they're gained, right? You've got to get into the labor market. So that's the baseline study. We're going to continue to look at this stuff and see how it develops. The report also points out, by the way, that women, compared to these other states, there's a far greater number of women who are business owners, who are CEOs in Illinois. And you'll like this one, a much higher percentage who hold political power. Right? That might actually mean something in terms of the kind of legislation that comes out of that political body. Okay, with that, thank you. I really appreciate your time. Very kind of you to let me.
Are there any questions for Dr. Bruno?
Yeah,
Or online.
two. One, on a larger picture, away from the family, specific woman and the children, what does that do to the nation's GDP?
Oh, yeah, and thank you. Boy, you want the data, right? He wants the GDP. And I don't have it on the off the top of my head. But women could contribute a very growing percentage of that gross domestic product, the way it's actually evaluated. It is a significant amount. It's a very high percentage, and of course it varies from state to state. But labor economists have determined that middle-class families over the last 40 years, so people working close, a little bit above, a little bit below, maybe the median family household, that had it not been for the fact that women, that they had a second income, if they had not been working, those families would have fallen, right? They would have fallen either by quintiles, that's the way economists like to look at it, they would have fallen out of that middle class, which would have put a lot of burden, of course, on the public assistance system, right? And people then would need to be either taxed to support that, or you wouldn't, and you would subject them to charity. The other thing is, you pull women out of the labor force, they stop being net contributors to the tax base that contributes to schools, hospitals, roads. Yeah.
well, you hit my second question, and that is states like Illinois that allow for abortion. Isn't it true that the state of Illinois contributes by way of federal taxes an enormous amount compared to what we actually get
Yes.
back?
Yes,
And wouldn't we argue that a lot of the money that gets sent to other states are states that don't allow for abortion?
I suspect that is true, and as you were talking, I was thinking, man, has he looked at some of our other research reports? We actually did a study in which we looked at the contribution in terms of federal tax to what the state received in a variety of forms of grants and aids, and compared Illinois to other states, and we are definitely a net contributor. And we came to the conclusion that we're actually subsidizing other states. And I wouldn't be at all surprised if those, in fact, well, I know at least two of them. I won't mention them, but they are states that are now restricting women's right to abortion. So we actually help to subsidize other states.
And it's only gonna get worse.
It would only get worse. It would only get worse.
Well, I imagine too that there are people making life decisions. Like my daughter's getting ready to go to college. So college students making decisions about where they're going to go to college, people making decisions about where they might move based on whether they have rights when they go to those states.
Yeah.
Right? And
Yeah.
that would have economic impact as well,
Oh,
assuming.
It absolutely would, and you would expect that it would, because they're at a critical time and they're going to have to determine, that choice of where they pursue their career and where they can. Now, on one hand, there's every good reason to think that Illinois, certainly it's going to attract women who are coming from Missouri. We've seen reports of that. There's been a real demand at health clinics here in Illinois. It's been very receptive as a state to women from other states, but it's likely to attract a lot of female talent also that would feel more comfortable working in Illinois, right? Where they could imagine they could raise a family when it's appropriate to raise a family, but they could live with a degree of freedom and dignity that may become less and less possible in the number of states that surround Illinois, and with its great public universities.
There you go.
I'll just mention one, University of Illinois, either at Chicago or Urbana. We will probably benefit from that talent. We'll come into the state.
There's a question online. Does your study include all parts of the state, urban, rural, community, suburban, etc.?
It does. Yes, it does. Yeah, it takes into consideration the entire state, the entire workforce, and it's true of Illinois and the 20 states that we're comparing it to. Yeah. Yeah. Good. Okay. Well, let me thank the league for letting me. I'm one of you, so it's great. We're doing the absolute best.
Thank you, Dr. Bruno. All right, well, are there more questions for Professor Schwinn or Dr. Bruno? Anybody? Yeah, Sarah has one.
I have one last one for Professor Schwinn. Where do we go if we think that this goes through with the FDA and we start taking that drug, and now that choice for that medical choice for a medical termination is going to be taken away? Where does that put us, and where does that put us on other drugs that we know have been approved by the FDA many times, that they now can go after? If it's not this drug, all sorts of other.
So there are a couple of weird things about the lawsuit, right? One is that FDA approved this back in 2000. So there's a long period of time where we have safely used this drug. And so it's demonstrated its safety features, right? The other thing is that Congress in 2007 more or less ratified the FDA's approval of the drug in 2000. And so you've got the subsequent statutory ratification of an agency action, which is also a little unusual, which sort of lends credence to the fact that this is a good and viable drug. I don't expect that the courts are going to pay much attention to any of that. I think that this will just get wrapped up in the abortion debates. And that our friends on the bench will decide with their politics and not so much the law, is what I anticipate. Now, it turns out that there are two drugs, right? One is being challenged, the other is not being challenged. And the reason is because it has a number of off-label uses that even opponents of abortion recognize are good for this drug to be on the market. The second drug can induce a medical abortion on its own, but with additional discomfort, pain, and potential complications, as I understand it.
Yeah.
As I'm not a historian, I'm also not a doctor, but that's what I understand. And so I don't know what's going to happen here. I don't know. But worst case scenario, there is the second drug. And again, the FDA could come back and recertify the first drug under different legislation or different rules or in a different way that then would sort of re-up it.
Maybe slightly off-topic question about the unprecedented leak of the Dobbs case.
Yeah.
When it
right?
came out.
Oh my
What
gosh.
was, do you have a view on kind of why that came down or what happened there? And, you know, what was someone objective or is there?
No, I really have no idea. And the court's investigation, such as it was inconclusive.
Right.
I really don't know. And I really don't. I have no special knowledge that would even allow me to speculate in any reasonable way. I just don't have any idea. I will say one thing though, for a clerk to do a law clerk at the court to leak that draft, I think is almost impossible to imagine. Because if that were ever revealed that a law clerk did that, it would ruin their entire career.
So you don't think it was a law clerk?
I don't think it could have been somebody in the staff.
Or even justice, right? Could have been justice.
Justice, right?
Yeah.
Yeah, so, yeah. That's all the questions.
As far as the living constitution, given the fact that the far majority of Americans believe in the right to abortion, and just another example with gun control, the far majority as well, Americans want far more gun control. This is just a matter of pendulum swinging back and forth. And we're going to create new laws, new Supreme Court's bring back Roe. And what's going to happen?
Tell us.
We have this group
50 years ago. There's hard determinate science in politics and history in constitutional, right? And the history, the court most often follows, not leads with where it's going, with some exceptions. But a little bit about is that there's now a 6-3 conservative progressive balance on the court, which and the court's young, which gives this 6-justice majority a lot of room to do a lot of damage for a long time. And undoing that, I think, is similarly going to take a long time. And so, yeah, there are cycles. I think we're in for a big cycle in the conservative direction. Now, you know, Justice Brennan, when he was on the court, was always keen on the idea that we should be looking to state constitutional law, that we ought to be exercising our rights at the state level, right? And we're seeing a little bit of that post-ops. Wearing my other hat, I've always advocated domesticating international human rights. And so Dr. Bruno, for example, talked about, you know, there's not a right to housing in the US, so there's not a right to education. Well, you know what? There is in South Africa, there is in India, there is in Australia, there is for goodness gracious in Canada. Why not in the United States, right? That's international law. And so I think if we think both bottom up and top down, we can start to move in the direction that public opinion is already moving.
I have a dumb one. Is it possible to amend the Constitution to give women reproductive rights?
Yeah, but it's so hard to do that. The federal constitution is so.
The ERA.
Yeah,
Why?
it's just hardwired into, it's baked in the cake. The formula for amendment is just really, really hard. There's a lot of buzz these days about a constitutional convention and getting enough votes to call a constitutional convention. I actually kind of worry about that because then it's just, you know, who can turn out the participants, right?
That's for the Constitution. You just bring up an amendment that would give women reproductive rights.
Yeah, you could. I mean, you saw what happened with the ERA, right? That was the most recent amendment that kind of died on the vine. Yeah.
45 years.
Unfortunately. Yeah, yeah, yeah. I don't hold a lot of hope for that. Yeah, I'll tell you, I was happy that Congress enacted a statutory defense of marriage. Understanding that Dobbs means that the Obergefell case for same-sex marriage is probably next on the chopping block. So let's get it into statutory law that there is a fundamental right. You know, if we can get majorities together in Congress and the White House that are like rights-loving people, we can do this as a matter of statute, which a lot of places around the world do, and it works fine for them. Thank you. Thank you.
Okay.
Okay, well, thank you all again. That was a great presentation. Those are great questions. And I love the term rights loving people. We need to elect rights loving people. Okay, so I want to thank everyone who attended this evening in person and on Zoom. And of course, a special thanks to our featured speaker, Professor Steve Schwinn, for his great presentation. We're all a little scared. We might not sleep well tonight, but that's okay. And to Dr. Bruno for sharing the study with us. That was very insightful. That was really helpful. So I think we all learned a great deal. A key takeaway for me is that civil liberties, especially that's freedoms that seem to be based on an implied right to privacy, cannot be taken for granted, right? Cannot be taken for granted. And while there's an erosion of established rights, and it's deeply concerning, we've got to find some hope and elect rights-loving people. Last year, there were reproductive rights initiatives are on ballots in like 6 states. And the people voted, right, to support reproductive rights, or at least oppose some possibilities of restricting them. Thank you. And also the League has a long history, over 100 years, right? We've been fighting for civil rights and social justice, and so have many other organizations. And the League's not going to stop. You know, to further quote the joint statement from our League's US President and CEO, the League of Women Voters stands in our power with our reproductive partners and all persons who fear the dangerous consequences of this decision. We will not stand by as constitutional rights are stripped away one by one. We will continue to fight. So, you know, what can you do, right? You can, of course, vote. We just pulled up some things about learning more. The League's US website has an explanation of the Dobbs decision, some sites you can go to for more history on the rights to privacy, and then acts. Again, the US League's website has a great list of some things that you can do. And one is to support the amendment of the ERA, right? So those are just a few things that maybe we can all do. And bear with me while we talk about some upcoming events. We have coming up on March 4th, a way for folks to get ready to vote on April 4th. And we have Dave Evans, he's co-voter service chair with our league, and he's going to talk a little bit about the Voter Expo that's coming up on March 4th.
So we have an election on April 4th, as you guys all know, but maybe not everybody knows. The turnout in our 2021 consolidated election, which is the consolidated election here in 2023, in DuPage County was 17%. All right. So every person that votes is voting for themselves and 4 or 5 other people. I think it'd probably be better if those 4 or 5 other people also voted. We have a few things that we're doing. The Voter Expo is one of them on March 4th. We're going to have candidates from school boards, 41, 87, and 89, answering questions. If you come in person, you can also write down a question and hopefully that'll get answered as well. And then after that, we have a meet and greet. We have some offices that are uncontested. And so we're going to have those candidates there as well. We have a few other things that you might want to consider. We have a blank form over there that looks like this. I vote because. You write your reason on there. Put it on your Facebook, tag League of Women Voters, Glen, Ellyn, and they'll make sure it gets amplified. I wrote one. Well, I wrote a few ideas. And then I settled on one that I thought, you know, and so I have mine, and I don't know if you guys got that or not, but if you haven't
You have
got
to come closer to the camera.
Or read it.
Read it out.
it says, I value democracy, and I vote because I value democracy, and voting is the only way to keep it working.
Yay.
If you're a registered voter in DuPage, you may have already received one of these. You can, you know, it has some information about the election. Today, I applied for my vote by mail ballot, so you can do that as well. Yeah, we have a get out the vote team also that's gonna distribute information throughout the village and about the election, and so we have that going on as well. So that's what we got going on.
Early voting starts today.
Early voting started today. Is that right?
At the
DuPage County
Fairgrounds.
DuPage County Fairgrounds, right. Right, and then in other locations, I believe on the 20th.
Yes.
Okay.
All right, great job.
Dave.
Thank you, Dave. Nice job.
All right, a few other things we have coming up on Thursday, March 9th. The consortium of the local businesses, along with Cantigny, will host a civic awareness program titled Banned Books, Intellectual Freedom, Libraries and You, featuring Joyce McIntosh of the Freedom to Read Foundation. And then on Thursday, March 23rd, our local league is hosting a program on mental health in Milton Township with an update on the 708 Community Mental Health Board. And we will also hear from 3 local agencies that's received 708 grants. And finally, you can find more information about all the events on our website. And of course, if you're interested in joining us in our mission to empower voters and defend democracy, check out the website. Again, thank you all for coming, and thank you, speakers.
Pick up a blank form on your way out.